Welcome, 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 welcome again. Today is Sovereign Citizens, and sovereign citizens are people who don't believe in authority. In other words, they don't believe that the courts, the police, or any government agent has authority over them. Again, I would like to thank all the new subscribers to this channel. Thank you, thank you, thank you for subscribing to my channel and helping this channel grow. Welcome. And let's try to get 500 before the end of the year. I know we can do it. If you like this content, please let me know that you like this content. I enjoy doing this for people and giving you an education to how the real legal system is. So let's go ahead and get started with today's sovereign citizens. And let's make this bigger. And
guarantee not to run that red light. I have proof that I did not run that red light.
We've also heard you had proof about being insured, and we haven't seen that either.
I'm trying to figure it out.
There we go. This is citation 25 RO06219, 6219A, and 6219B. The A ticket, or the first ticket, is driving on expired plates. The second ticket is driving without a proof of insurance. And the third ticket is disregarding a traffic signal. Was your vehicle insured on the third day of October when you got these tickets?
Before I can even proceed, Your Honor, I have put in for a fair Information Act, Freedom of Information Act, so I can disclose my grounds of filling this stop itself. It has not been honored. That is fraud. I have given the courts plenty time, the police station plenty time to retrieve all the information of this Freedom of Information
Let's
Act.
understand one thing, sir. You scheduled this hearing.
Yes.
This hearing is happening because you requested it. I'm asking you, was your vehicle insured on the second day of October, third day of October?
I got all this proof here, but my issue.
You can answer my question with the one word.
Yes.
Yes or no?
It is. Yes,
Okay.
it is. Yes, it
Do
was.
you have a certificate of Michigan no-fault insurance that was effective on the third day of October, 2025?
Yes, I have all of that proof right here.
Where is it?
Right here. Let me see if I can turn my camera. I'm about to try to turn my camera around.
Okay.
This is my insurance that was effective for that vehicle on that date. And I just told the officers that
You've moved the thing faster than I could read it, sir.
Oh, I'm so sorry.
Vehicle. Now I've lost it. Mr. Allen, I think if you speak, the camera will focus on you again.
Okay. Yeah, so
we still haven't seen the document, sir.
Okay.
I see a 2414 Traverse or Chevy.
Yep.
I can't see the VIN. If you would hold it still, sir, it would really help. Can you move it? Right now, we're seeing the right side of the document, not the whole document.
I can't see it.
Mr. Allen, there is on that document a vehicle identification number.
There it is, boom.
It ends 452, as does this one. Okay, now can you slide it over where I can see the effective dates?
There's no effective dates.
Go to the left. Go to the left a little bit. So it's 10/6.
Ticket is 10-3.
Yeah.
Can you need to speak up, sir, so that the sound of your voice will make the camera focus on you and we can see the document?
Okay. So, Your Honor, I am objecting to this.
I don't care if you're objecting now. I'm trying to read your document that you're proffering.
I'm trying to present it to you. I'm not going against the court proceedings.
I want to see the left side of the document, please.
That's the sound of an American oil company hard at work.
Six to 4/6/2006.
10-6 of 25 to 4/6 of 26. Yeah. You have the one that was in effect 3 days before?
Yes, I've been had this insurance, but my honor, I'm still trying to have the validity of this traffic stop to be questioned.
You're the one that requested the hearing, sir, and I'm asking you
Yes.
if you have a document that shows that your vehicle was insured on the 3rd day of October. You showed me one that showed it was insured on the 6th day of October.
No, this is the printout of it here.
No.
Your Honor.
Wait a minute, Mr.
Are you
Allen.
still there?
Mr. Allen,
Yes.
do you have a certificate of insurance that covers the date October 3rd of 2025?
I have printed out that this court case is.
I didn't care about the court case you printed. I
It's a
asked you a document. I've asked you if you have a document.
What
Do
I'm
you have a
asking,
document that shows that your vehicle was insured on October 3rd?
I just presented that to you, Your
You
Honor.
presented something to me that showed it was insured on October 6th.
This was the same information that I had previously.
You-
Yeah, he told me, Your Honor, what I asked for is the audio for this stop, because this stop has proven that.
We don't need the audio for the stop to determine if your vehicle was insured.
I object to
I've
this
asked
whole
you
proceeding.
repeatedly, Mr. Allen,
I object to this proceeding.
Mr. Allen,
I'm not trying to have a difficulty with this
you are
proceeding, sir.
creating a difficult time for yourself because you're not responding to the questions that I've asked you. Was your vehicle insured on October 3rd?
Yes, I had insurance.
Where is the certificate of insurance that covers that date?
I don't have it with me at this time.
This is the time for the hearing, sir.
Yes. At this time, I got my registration, proof of my registration.
Mr.
not-
Allen, I don't care if you've got your birth certificate. All I want to know is where is the certificate of insurance that covers the date October 3rd?
Your Honor, what I've asked for prior to
I
the proceeding.
didn't ask you for anything.
No, I'm telling you that
Yes.
I cannot produce this information for you because I am having my rights of due process violated on the record, for the record, let the record reflect. I'm here as the authorized representative trying to present you with what
You're
I
not an
have.
authorized representative. You're a driver who's been cited for running a
Sir,
red light.
I was traveling and I wanted the proof of this running the red lights, what I've asked for, which is the beginning of this stop. So this stop was because he said, and I have it here on the date that I put in for the paperwork for the Freedom of Information Act, which gave you enough time to prove that I ran this light. So my first stance is that my rights of due process is being violated because you all have not presented.
You do not
what my
have a
grounds
right
are.
to run a light.
No, sir. I'm
There is
stating that I
no
did
right
not.
to run a light.
I am guaranteed not to run that red light. I have proof that I did not run that
Okay,
red
we've
light.
also heard you had proof about being insured, and we haven't seen that either.
No,
Where
what
is
I'm
the
stating,
certificate of insurance that covers October 3rd?
what I am objecting, Your Honor.
I don't care if you're objecting. I'm asking you a question.
I
Do you
presented.
have the certificate of insurance that covers October 3rd?
I only have what I printed out, which was insurance on the vehicle, and I've showed that I have insurance and registration. But before I can proceed forward, I'm asking you to dismiss this case because I don't have you haven't presented the grounds that you have had me underneath.
I don't
proof
need
of-
to present anything to you, sir.
This gentleman has stated that I ran a red light and I asked for the proof from his dash cam program. He did not prove that. I have proven that I was stopped illegitimately, and I have no ways of fighting
You
this
have not
case.
proven that, sir.
No, I am saying my statement versus his statement. I did not run a red light, Your Honor. First and foremost, Your Honor,
Let's
I'm
go
being
back.
in honor of
Hang
this
on, we're
court.
going to take these things one at a time.
Okay, in honor of this court,
No
I am
proof of
stating.
insurance. I'm
in honor of
asking
this
you to
court.
stop talking.
Yes, sir. Let me stop.
We're going to deal with the tickets. The
Yes.
ticket for no proof of insurance. You've denied responsibility, but you've been unable to show a certificate of insurance that was effective on October 3rd. Instead, you showed a certificate of insurance that was effective on October 6th. It's the finding of this court that you're responsible for that civil infraction, and the fine is $175. Now we can go on to the question of whether or not the license plates on that vehicle were current. Were the plates expired on the car on October 3rd?
The validity of this stop is in
I'm
question.
not, he doesn't,
And I'm
that's
stating
not
that
the issue.
I cannot defend this case until you present your proof of the validity of this stop. I have put in for the Freedom of Information Act.
I've asked
asking
you
for
if
your
the,
courts.
did you
Asking
have
for
a
your-
current,
I
was
cannot
the license
proceed.
plate? Oh,
I
Well,
cannot proceed
then-
until you all. I am
Then
not
we're going
giving
to
you
ask the officer. Officer
Your-
Stokes, when you stopped this vehicle, was the car plated?
I'm sorry, was the car plated?
Was there a license plate on the car?
Yes, there was.
Was the plate current?
It was not.
When did the plate expire?
August of 2025.
And the ticket was issued on the 3rd of October. Mr. Allen, I'm going to ask you again, was the license plate current when you were stopped?
At what I'm stating, Your Honor, I cannot even protest this stop.
Then you're
due to
found
validity.
responsible.
I would like to.
The officer's testimony remains uncontroverted.
It is being protested because the validity
You
of
can
this stop.
protest all day long. You've got the right to protest. You don't have the right to just waste everybody's time, though.
I'm not trying to waste your time. What I'm stating
are.
here, Your Honor, I'm asking you, magistrate, would you listen to what I'm stating? The
No, I'm
validity of this
asking you.
the validity of this traffic stop is due to profiling. The gentleman decided to make a false accusation that I ran a red light to pull me over. He
He
stated on
didn't need
camera.
that accusation. He doesn't need to make an accusation.
He
You're
has to
driving
prove
without
this.
current plates.
No, he has to prove that I ran a red light with the reason. I have proof
No,
that this
sir, he
officer.
can stop you for driving without current plates.
First off, I told him, and I'm clearly explaining to you, I was not driving at that moment. I was traveling from the dentist's office, and I'm doing this with the rights of travel, and I'm protesting that the validity
But
of
you're
this
saying you
traffic
weren't
stop-
driving at the moment?
I was traveling from the dentist's office. I
Were
was
you in
not
a car when you were traveling?
I was in my personal conveyance traveling from the dentist's
Were you
office.
sitting behind the steering wheel?
Sir, I'm a state citizen, and I'm trying to my best to proclaim my rights to allow you all to do your job as magistrate to
Oh, I've
validate.
done my job.
I need you to validate this officer's means of stopping me. What I have asked for is proof that this officer has followed me through 90 miles an hour on the road to pull up behind me, and I thought there was an emergency, and he slid past the left lane, and he stated that I ran a red light. That is not true. The things that he asked me on camera to present at the time of trial, he said, if you can present insurance and registration, I will make sure I take care of this ticket for you. I presented
done
insurance.
neither.
I presented insurance and I presented a registration. He said,
No,
if
you did
present-
not.
He
You
asked
did
me.
not.
I presented
You
insurance.
presented neither. You presented insurance that was secured 3 days later.
He stated if I present insurance at that
Let's
time.
deal with
he
the
did not-
license plates.
he
We've
did not-
played
he
enough
did not-
on the
I
insurance.
have on record, sir, if you pull up his camera record, that he did not say anything besides if you present insurance and registration at the time of the court case, I would take care of the tickets. And I have that on
The word then current might have been forgotten by you.
No, I'm sure he stated that if I come and present that I have insurance and registration up to date, valid at the time of the court date, he would take care of the tickets. I have that in his audio. You have not given me a chance to present his audio that stated if I have insurance and registration at the time.
How can you have something in his? Do you have the audio?
I'm requesting this audio, which you all have not, which is fraud. So
I don't have any audio. Don't tell.
Okay.
Wait, you're accusing the court of fraud?
No, I'm saying it is fraud for you all not to give me.
No, we all aren't doing anything. We're just playing around with you as you want to deal with facts other than what's relevant here.
No, what's relevant is
were
that
the plates on your car current when you were stopped? Yes or no?
I have no understanding of this court case besides me being stopped and not having my rights, being a right of due process. I'm asking you all.
Officer Stokes, would you please testify as to the citation that ends 6219B?
Is that
That's the red light.
okay? Yeah. So I was eastbound 13 mile behind his vehicle, and when we came up to the intersection of eastbound 13 and Campbell, the light was yellow, then turned red, which he proceeded to go through the red light, at which time I activated my overhead lights, went through the intersection and pulled him over probably, I'm going to approximate it, but maybe 50 to 100 feet east of Campbell on 13 mile.
So just north of, just west of that same location at the light before, I got to pull up my printout of where I requested it at, the exact location. This officer had engaged in a high amount of speed to pull up behind me, and I was making a right turn in the construction
Mr. Allen,
area.
I don't care if he's driving a helicopter. The question that we're dealing with is whether or not you ran a red light.
And I'm guaranteed not to run it, and that's why I asked for his dash camera, and I asked for it enough time to present it. And this is the validity of his stop. If he can accuse anyone of doing any traffic infraction to see if they have insurance in place and anything, and then he lies and states, if you have it at the date of the trial, I'll take care of the ticket, and I'll have that on his dash camera as well. And he don't produce any proof that if I have insurance, which I do have insurance, if I have valid registration, which I do have valid registration, he just stated, if you have it at the time of the case, I will take care of the ticket. And that's on his dash camera, he clearly stated. Anything else, me knowing, me telling you anything besides, I literally did not run this light, and I asked for the dash camera to prove it. And I gave you guys enough time to prove this validity of this stop. The stop was a profile stop, and from way to the beginning of Glendale, is right past Glendale, the light right east of Glendale, that first light, that officer sped behind me, and I watched him do at least 70 miles an hour to pull up behind me, to pull me over, and to say that I ran a red light, which I know I didn't. Traffic was directly behind me when we went through, and there was a car in front of me. And if I just asked for the dash camera to prove the validity of his stop, because this is the beginning of this whole case, is that the cops have rights to pull me over and to question me or anything due to what his camera showed, and you have not presented that. So you violated my right of due process to even go forward in this case, because you have not presented my Freedom of Information Act, which I again asked for in ahead of time. I can't even protest.
You were driving a vehicle that didn't have a current license plate.
What I'm telling you is,
that's the only reason the officer needed to stop you.
What I'm telling you is, I was traveling, and he made an accusation that I asked to be validated through his camera, and they did not present it. That's why I'm here. And I'm only asking for you all to look at the camera and to see that I didn't run a red light, so I can start fighting these tickets that you're trying to put on me. And then he said to me in his camera, if I present my registration and insurance, he will take care of the ticket. That's also on his audio. I presented it.
The reference would have been to then current. If you had insurance, but just didn't, but just not talking long enough.
Yes, I apologize.
If your vehicle would have been insured, and you just didn't have the document, the officer is telling you that if you presented the certificate of insurance, that he would have dismissed it. But
He
he's
tells me
not
at the
telling
date
you
of
that if you go back and get insurance a couple days later, it's going to be okay.
No, that's not what he stated. He stated if
And
when we
even
hit
if
my
he
point,
did, it wouldn't matter. The citation is what it says. It doesn't say it's a waivable.
what I'm saying
A
is,
uniform
he asked
traffic
me,
citation form provides for an
I
option of being a waivable ticket. That is not
not presenting,
your matter.
not proceeding in this, not presenting the Freedom of Information Act information I asked for, his dash camera, proof of the validity of the stop, all the way to his things that he asked for. I need that, and that's the only way I can proceed in this case. I'm asking you to dismiss
That's
this
not
case.
true. Mr. Allen, it is
How can
not
I?
true
How can I
that
prove
you
the
can
reason he
show.
stopped me? If he stopped me for speeding, sir, and I asked for proof from his dash or anything of speeding, and then you can't prove that, but then all of a sudden you got I had no seatbelt on and all the rest.
No,
All
we're
these
talking
minor
about a
things.
license plate that's out of date. That is the license plate being less than current justifies any traffic stop. Nobody is going to drive in front of a policeman with no current license plate and not expect to be stopped.
The officer profiled me by speeding up a quarter mile behind me to stop me and then say that I ran a red light, which I did
And
not.
you're saying that he profiled you because of a racial issue, but you're a quarter mile in front of him and he can tell what your race is. That is absolutely preposterous.
Saw me at the turning light when I made a right. He was at the intersection. When I made my right, he looked at me right in my face, and I turned right, and then he sped up, and I'm asking for that proof that he actually sped behind me to cause me to be pulled over. I did not run no light, so I need to see the proof of
Mr.
that
Allen,
light.
I will tell you that I do not believe your testimony that you didn't run the light. Whether
I
it's
have my children
intentional fabrication or not, I'm not addressing. What I am saying is I don't believe the
sir, I have
fact
no
that you
records.
didn't run the light.
I have no record of having even traffic violations, no problems of speeding, running red lights, or anything of the sort. There was an intersection that had construction at that time. When I started to make the right, I stopped at the light because I was making a right, but there was construction there. I did not make that right. When the light turned right after,
Mr. Allen,
I went
did
straight.
you not tell me that you've never had a ticket?
No, I'm saying you don't see me having tickets of running red light, doing anything of that nature.
And you said you don't have tickets for speeding. And you do have tickets for speeding.
We have all possibly made.
You also have tickets for not having insurance when you're driving.
Those were new vehicles. That was only when I bought a new vehicle. That was
So it's okay to
time
speed if you got a new vehicle, and they're not. They're 3 years apart.
No,
Mr. Allen,
I'm not authorizing speed.
There's no doubt in my mind, as I sit here, that you ran the red light. There's no doubt in my mind that you did not have your car insured on the 3rd day of October. And there's no doubt in my mind that the plates were not current on your plate on that day. I believe your plates were not current. The fine for the plates is $130. The fine for the no insurance is $175. The fine for running the red light is $150. These can be paid online or by mail or at the courthouse.
Well,
counter.
I'm objecting to this, Your Honor. I understand.
That's fine. You have the right to object.
I actually told you all that I'm a state citizen, and you guys have.
We're good.
Good.
Good morning.
Good morning, Your Honor. Yeah.
Good morning, everyone.
Good morning.
All right. Are you ready on the motion for Michael? Is it McCreary?
Yep.
All right. The clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCreary. Mr. McCreary is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons and ammunition possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm, with the habitual offender fourth offense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCreary to disqualify me from this case, and that is why Chief Judge Conoco is on Zoom to address that motion.
Okay, appearances.
Edwin Sawaki, P54A28, appearing on behalf of the people.
Colonel Michael McCreary, natural person, not a corporation, natural flesh and blood.
Thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Abri pursuant to MCR 2.003. The court, having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turning over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.
Well, can I at least place my objections on the record?
It's been noted.
I mean, I'm just saying
Mr.
because
McCreary,
I thought you were the chief.
Mr. McCreary, your objection has been noted.
May I address the court?
Not on that matter. I can't hear a motion to disqualify. According to Michigan Court Rule 2.003, the chief judge has to address it in a multiple
But that's not how the rule.
multiple judge court. This is a multiple judge court. Chief Judge Conoco just addressed it. You received your motion in writing and he responded on the record and he denied it. There could be no more discussion from me about the disqualification motion, Mr. McCreary. It's been denied.
But can I just address something? I mean,
It's already been addressed in your pleadings and I cannot respond. I don't know if you understand. I can't respond regarding the disqualification.
I'm not trying to do that. What I was saying per the rule, the process.
You're still talking about something that has nothing to do with.
Well, I object and it's on the record.
Yes, and I've noted that. So as far as the exam, the time is now 10:17. Are you ready to move forward with your preliminary examination?
I came here today with intent, like.
Yes or no?
No, I'm not prepared because of this. I mean, I would like, you won't let me speak, Judge. Like,
I
you give
know
him a
you
fair
speak in regards to what
chance
I'm
to
asking.
respond, but you won't give me a fair chance to say or speak.
Mr.
I mean,
McCreary,
this
I
is-
let you stand here for 45 minutes last time we were here talking to you, didn't have anything else to say. So today I'm asking you, are you ready to move forward with your exam?
No, I'm not. I would like to call
Based-
witnesses. and
Based on
subpoena.
what?
Pardon?
Based on what?
Because my intent as today, this motion was filed, the court was supposed to deny it because I thought you were the chief judge pro tem. And per the motion, it says that if you were the chief judge pro tem, it was supposed to go to the state court administrator. This gentleman here, I'm not familiar. Like first, the
You're
way the
still
rule-
addressing the motion to
my due
disqualify.
process is being
And
violated, Judge.
it's not.
I mean,
Because if
you won't let me
read,
tell you
it seems
why.
as if you can read it right. The court rules are very clear about motion to disqualify. There's no it's black and white.
But,
So, Mr. McCreary has been denied.
okay, we
And
understand
if you
that.
knew that, it also says that there's a timing in which the court can address that, can be any time. So you knew you need to move forward with your exam today.
Well, what I'm saying is I
So-
have a right under 6.110 to call witnesses,
Yes, you
things of that
do.
nature.
And why aren't you prepared today?
Because you won't let me speak.
I
Your
didn't,
Honor.
no, I said, why aren't you
I'm trying
prepared
to,
today?
I'm trying to tell you.
Today's your exam date.
Can I respond? You keep cutting me off, Judge.
You're not answering my question.
I'm not prepared because when I filed this court was supposed to make a ruling. Then if you denied it, it was supposed to went to the chief judge.
No,
That is the
I like to
process.
tell you no. It's not.
That's
true.
why I'm not
I can't deny a motion to disqualify in a multiple judge court.
Can I pull up the
Read the
rule?
court rules,
Can I-
2.003.
I'm familiar with it very well.
We're not that
In
familiar.
Crampton versus Michigan Department of State,
You
said
can
even if
say
you
any
can't
case
show
law you
bias.
want in a multiple judge court. I cannot handle your motion that you filed. It goes to the chief judge. Chief judge, I am chief judge pro tem, two different things. I cannot handle my own motion to disqualify. That would be bias, Mr. McCreary. So do you have witnesses subpoenaed?
You won't let me respond.
Yes
to
or
this.
no?
No, I don't.
Okay.
Because my intentions, as I stated, under this
It's just a
rule.
yes or no. I just want to know.
I
So
mean,
you can finish looking under court rule 2.0.
Why am I not being allowed to address the court and give it a fair exchange like
I'm
the
asking you
prosecutor's
questions. This is not your courtroom.
office?
I'm asking
I'm
you.
not trying to
I
disrespect
have
this court.
given you all the leeway up until this point.
I mean, the law
Today's
gives
the
me
exam
rights.
day. Go ahead and check your court rules. Get back to me. Are the people ready to proceed?
People are ready to proceed, Your Honor.
And I object, I'm not ready. Because, I mean, I would like to address the record for preservation rights. So far as I have to go to the
Do you
higher
want to
court.
research 2.003 first? Because that seems to be what you were stuck on. Maybe, I want you to go ahead and
I
find
mean,
that
there's
first.
Michigan case laws, but I'm just.
Court rule 2.003. Go ahead and find it. Tell me where it says that I'm supposed to address.
Okay, section B, who may raise, the party may raise the issue of a judge's disqualification by motion, or the judge may raise, excuse me. B, disqualification of judges warranted for reasons that include but are not limited to the following. The judge is biased or prejudiced for or against a party or an attorney. B, judge based on an objective and
Those are the
reasonable.
grounds. You gotta get to procedure. Section B.
Oh, my goodness.
I can read it for you. 2.003 D3 under ruling.
I mean, I was getting down
One,
here.
in
You
a
say
court having
B3?
2 or more judges, on the request of a party, the challenged judge shall refer the motion to the chief judge who shall decide the motion no. The written order that will be provided to you stating the time. So, Mr. McCreary, I am ready to move forward with the people's witnesses.
Well, I have evidence, I mean, since you're forced and compelling, which violates my rights under UCC 1-3. Also, I'd like to make a non-pro time. Again, motion to challenge the jurisdiction of the court. After this, the hearing we had last, I believe it was the 30th, I believe it was. The prosecutor gave me 15 pages. He attested on the record, this is 15 pages on the app. There's no warning. There's no signature signing off for the prosecutor to initiate charges, whatever else. I mean, this whole case, I object to this case being moved forward under Brady violation, Fourth Amendment violation. I mean, they're committing crimes here in this courtroom, and this judge, you're allowing this.
Nothing has been presented to me.
I mean, I'm just saying.
I'm talking. Stop talking over me. You've been doing this since you've been in this courtroom. Every time you talk, I let you finish, whether it means it's meritless or not. I haven't heard anything of any substance or any value worth me addressing when it comes to Brady violations. So I'm ready to move forward. And if you want to call witnesses, and we have to hold in part because you didn't subpoena them today, we'll address that when it comes time after the people rest. So Attorney Washington, is there anything you'd like to put on the record before we begin?
No.
Okay. Any preliminary matters from either side regarding the exam?
Preliminary matters, yes.
People have to address the court first.
Yes, Your Honor. People have exhibit 1, which I will show to the defendant and his Mr. Washington here. It is a register of action certified, case number 98007-861-01-FH. It indicates that defendant, Mr. McCreary, pled no contendere, assault with intent to maim, would like this as People's Exhibit 1.
Oh, you say, I was found guilty. Assault with intent to maim. Hold on, he said I was convicted of that?
Under what statute?
Oh, I'm sorry, Your Honor.
I object, I wasn't convicted.
MCL 766, 11B, 1B.
I object to that, Judge. I was not convicted of that. Matter of fact, Judge Dawney Robeson was a visiting court. And again, this gentleman is lying to the court. He just lied to the court. That's perjury.
Have you had the opportunity to review the document?
Well, he said that I was convicted of assault with intent to maim. Can I ask that what you said?
I said, you pled no.
No. I wasn't found.
Mr. McCree, you review the document first.
Yeah. Check, well, what does this got to do with the case? Robbery not armed, and assault with intent to maim. I have the transcripts at home. And the court order from Judge, he was a visiting Judge Dawney Robeson. Matter of fact, in that case, Your Honor, the prosecutor, what was this, Thomas Beadle, I believe his name was, he said that the officer in this case lost his entire file.
Can I see the?
And I have this transcript at home. How you gonna speak on something you lost a file? This case was what the felonies was. It was a misdemeanor, aggravated assault. And that's the case that, because in the transcript that I have at home, I would like to make that in evidence after this is concluded or whenever I can. Because he's just lied to this court, Your Honor. That's perjury committed in court, Your Honor.
Okay, I have a seal here from the register of action sealed from the Wayne County Clerk's office stating that you pled no contest to
That's inaccurate.
assault with intent to maim.
That's inaccurate, Your Honor. I had a transcript at home.
Can you let me finish what I have to say, please? You were sentenced and committed to Wayne County Jail. Your sentencing on September 8, 2000. So for exam purposes under MCL 766.11B1B, exam purposes only. This satisfies with you can place your objection on the record.
Well, I would like to say, because in this case, I have the transcripts at home. And I object because this man just lied to the court, because in this case, Thomas Beadle was supposed to be the special prosecutor. They held me there for 2 years. Then he stated on the record, there's no support for this case. The officer in charge lost the entire file. So how are you going to present a register of actions? That's not evidence, Your Honor. I have the evidence at home. And I would like to object to this, and I would ask that you hold him in contempt of court for committing perjury.
I'm going to hold you in contempt of court in a minute if you keep talking over me. So I'm going to admit as Exhibit 1 over the objection of defense as a certified copy from the clerk's office for exam purposes only, showing that Mr. McCree was convicted of assault with intent to maim in 2000. Anything else for preliminary matters?
Not from the people, Your Honor.
Okay.
Also, Judge, I would like to make a motion to sequester, because my intention is to call the chief detective on the stand, because.
Okay. You don't have to tell me a theory. I will do it.
Okay.
So let me do that first. So if there's a potential witnesses on this case, now is your time to log off. As far as in the courtroom, if there's anyone present who may testify on this case, maybe a witness, now's your time to exit the courtroom. What's next?
Per the court rule, I'm allowed to admit evidence for evidentiary purposes of impeachment on People versus Stanaway. I also would like to address to the court, Kim Worthy, last year, put a witness list out for officers who have previously testified falsely in court proceedings, that they couldn't testify in future proceedings. My brother, Norman McCreary, has committed perjury in front of Chief Judge, Wayne County Chief Judge Freddie G. Burton. He committed forgery, as well as identity theft. Also, I have affidavits from my other brothers where they've been trying to press charges. I tried to press charges, and the prosecutor is not doing anything. Also,
let me address that first.
Yes.
So, Mr. McCray, if your brother testifies, you can definitely cross-examine him, impeach him, and bring all of that out. And if the prosecutor objects, we'll address it then.
Well,
but you can do that on
I need to get y'all copies.
No, I don't receive copies until you introduce it and it's provided to the court. I don't do any preliminary impeachment. So once you cross him, if it comes out that he was convicted of a certain crime under the court rules or under evidence that allows you to discuss it, then that's your right to do so. Next.
I would just like, he was not convicted, but he was in the courtroom. It was established by the Chief Judge Freddie G. Burton. And my other brothers were kept in the mind all these years, and they're trying to come forward. And I have an affidavit on my phone from my brother that's notarized. He's in the state of Florida. And
The brother that's testifying
no,
today?
my brother Charles had 5.
So you have to address your brother today, when you cross-examine, okay?
Also, again, I would like to renew my motion to have the prosecutor's office withdraw because of criminal misconduct, conflict of interest. My former attorney works for Kim Worthy as the director of the wrongful convictions unit, Valerie Newman, and it is quite well documented that Kim Worthy, as well as my former attorney, committed felonies. And it's all a matter of public record. And you know, for this gentleman here to come here and try to mislead the court, I believe it's under 3.3 of the Michigan Rules of Professional Conduct. It states once an attorney knows, I believe it is, that they have told the court something, they must correct it. And this prosecutor is committing misconduct because I have from a stenographer transcript at home, in which I would like to.
You know the avenue to do that. If you want to report misconduct, you already know that. So let's get started with the exam. I've heard all of your motions, and you place it on the record, and you will, of course, order the transcript to be able to move forward to the next step that you want to do. So any other preliminary matters to address regarding the exam today?
Well, how about, I'm just saying this, the recusal aspect.
No, I'm going to deny that.
Well, can I place my objection?
Absolutely. I hear your objection, everyone else does. Ready to call your first witness?
Yes, I am, Your Honor.
Mr. McCree, do you want to sit at the table up here?
I would ask that the police officer be called first because we have to establish how he investigated and other things that nature.
Now that would be you working for the prosecutor's office. You don't get to tell them how to try their case.
Well, I'm not saying that. What I'm saying is I want to question that investigation.
Okay, and if the prosecutor, are you going to address their request? Or call who you said you're gonna call?
I have one witness.
Okay. So in this case, he gets to
Well,
start with
can I
however he
call
wants to.
as a witness? Being that he's trying to bring my brother, I would like to
So
establish.
procedurally, prosecutor has the burden of proof. You should know that. So
Well,
they have to go first. They have the burden here.
well, they have no
And
evidence,
you
Your
can
Honor,
call
for the.
witnesses if you like to. If
Yes.
you feel necessary, you can do that. We'll discuss that after the legal rest, okay?
Yeah, they have no evidence, Judge.
You don't know what they have.
They just said it's in the paperwork.
I'd like you to stay focused, okay? And the first thing we're gonna do is hear testimony from the people's first witness, that they have a record. So please, call your record.
People call Norman McCrary. Sir, could you state your name for the record, please?
Norman Leon McCrary.
And what brings you to court today?
The incident that happened on,
Well, the holidays have come and
the night, and, I was, leaving, the house after, another incident that happened inside of the house,
Okay,
and I went to my next door neighbors.
okay. Let me back you up a little bit there. Was that February 9th this year?
Yes,
Yes, and did that,
Objection leading.
Piece of paper,
No, I have some. Objection, he's leading the witness, Your Honor,
I think, sorry, go ahead.
because he said it might.
one witness testified that it was night, I was merely, clearing up the accident of which, that's in the county.
yes, my county.
Because all the CEOs work together. Now, you had confrontation, right?
Yes, if that's what you want, yes, a confrontation, we talked after
Okay. Who did you have a confrontation?
Colonel McCrary sitting right there.
Could you,
Objection, Your Honor. I would like to also, there was one single photo lineup, which he seen my picture prior to this exam. It was a photo lineup, single. And this is how, you know what I mean, he's my brother, truth. There's a procedure on the due process.
Stand up for you.
Oh, okay. Yes, I
I
would
know you
like,
have back issues, right?
I mean, I'm good, but I would like to object because there was a suggested photo lineup used. If you look at this discovery, it says that a single photo was shown to Mr. McCrary. And this violates, what is it, United States versus Wade, I believe it is.
It would be way to address that. However, Mr. McCree, that's fine. It's very delicate. sure you represent yourself. You just stated that he's your brother.
I mean, but it's
So-
still a procedure, Your Honor, that has to be followed.
I mean, this is one of the most easiest identification cases. If he knows you as your brother, he can identify you from that day.
But it's still, it's suggestion, it violates the law. Your
We're
Honor.
not even getting to the line at this point.
Well, I'll place my objection.
I hear you. So, Mr. Walker, can you continue with your questioning?
Could you describe a piece of clothing that the gentleman?
He has a blue jean jacket that I gave. Come on.
Your Honor, let the record reflect that witness has identified the defendant.
It's not reflected.
What, at this address, you arrived at it, you had a confrontation. Could you go more into that?
Well, prior to, seeing, my brother Carnell, I had went into the house the day before on the 8th. And, the downstairs door, which is the part that I had, was kicked in and damaged. So, and then I went into the back room and the second door was kicked in and damaged.
Objection, Your Honor, he just committed perjury. The first door is not kicked in, it speaks of.
Sir,
Oh, okay, I'm sorry, I didn't know I had to say it, I'm sorry.
what you're doing is you're testifying as to what happened. All you can do in this case, if you're saying that he's not telling the truth, is on cross-examination, you have an opportunity to question him and possibly raise issues of credibility. But at this time, you're testifying as to what happened and not an objection regarding the rule of evidence. Okay? Every objection has been placed.
I understand this, man.
And if I may finish, though, and upon, going into the kitchen.
Second. Describe this house, is there like, is it an apartment?
It's an income bungalow. So it's the upstairs and the downstairs, and they're separate, and they both have separate utilities. And the downstairs is the part of the dome so that, I was, having, I became executor of the estate. So, I kept the house so that my other siblings, including him, could stay there.
Okay.
So I came downstairs.
Say him, who are you referring to?
Cornell McCreary. So when I came downstairs,
Just so the record's clear, whose estate are you talking about?
my deceased mother's estate, Mamie McCreary.
Who lived up, did someone live up in the?
Cornell McCreary stayed upstairs after he was released, from prison.
Okay. So, you came in and there was damage?
Yes, there was damage to the front door, the kitchen door, and a bedroom door.
Okay. What happened?
Okay, so
And this is on the 8th.
yeah, so I didn't have a camera with me at that time to take pictures of the damaged property. So I came back on the 9th, and then once I came back on the 9th, I took pictures of the damages that were, incurred in, the house.
What, after you took the pictures, what did you do next?
I left the house and then I went next door to one of our neighbors she had fell sick and she had a pacemaker. So, she grew up, we grew up with her, like, she's like a mother.
Okay.
So I went next door and, visited her, and then upon leaving, when I was coming out, my brother was coming, Cornell.
Okay, you were coming out of the neighbor's house, where was your brother coming out?
He was coming out of 1417 home.
Okay, and that's where he lives, correct?
He lives in the income bungalow upstairs.
Okay. What happened when you got it?
He confronted me and, I told her, I said, so is this how you're gonna do our mother's house? And he was, he started talking about taxes, which he hasn't paid, So, and then I was like, man, I tried to ignore him. So he's like, so you going to go to the police on me and all this kind of stuff. So, and, I was like, yeah, I'm going to the police. And he's like, well, somebody's gonna die today, me, you, or the police.
Okay.
So, and then I ignored him, and I went to my automobile,
Okay.
and I was about to get into our automobile. He picked
When you got into your automobile, what happened next?
he picked the brick up and hit the car with the brick.
Okay.
So I jumped out of the automobile and, ran after him, and he ran. So, I was like, man.
Okay. Where did he run?
He ran up on the porch of 147 down.
Okay. You sit tight, Your Honor. When he ran up, when he's on the porch, what did you do?
I went, I ignored him and went back to the car because I was going to go to our police.
Okay. And when you went back to your car, what happened then?
He picked the brick up again and hit the car again. So now this time I ran after him again, and he ran up onto the porch, opened the door, and then came outside with a semi-automatic weapon and fired into the air twice.
Okay. He fired it twice.
Yes.
And then what did he do?
And then
I'm sorry, did you say into the air?
yes, into the air twice. And then he looked at me in the eyes and then pointed the weapon at me and shot in my direction. And,
Okay. When he shot in your direction, where did the bullet go?
it's a field right across the street from the house. So I can't say where it went, but it went in that direction towards the field.
Well, what did that do to you as far as?
I was, first of all, I was upset that my brother would do something of that nature. Then, I kind of feared for my life, so I jumped into the vehicle and drove off.
And you said the weapon was, what type of weapon again?
It looks like it was a rifle, it was a black, it could have been an AK.
But you're not sure, right?
No, I'm not sure.
And after you got in your car,
I was really upset, I went directly to the precinct and I filed a report.
okay.
And
I have nothing further for this witness at this time, Your Honor.
Ross, did I make it?
yes, I mean,
And Mr. McCray, at this moment, you know, you are bound by the rules of evidence. If the prosecutor objects, if you need any help with it, Mr. Washington is there for you. Okay?
How you doing there, Norman McCurry? I'm here. You all right today? Okay, let me direct you. You stated that I shot in the air. Is that correct?
that's correct.
Okay, isn't it also correct that you said I shot in the ground as well?
I didn't see you shooting the ground.
Well, no, I'm just saying, is it yes or no? Did you say I shot in the ground?
I didn't see you shooting the ground. So
Okay. Your
it's not
Honor,
a yes or no.
I would like to reflect for the record that at another proceeding, the prosecutor stated that he said that I shot in the ground, shot in the air, and shot him in 3 stories. Okay.
Your Honor, I don't recall that, and
This
today
was
we have to
a,
go by testimony of the witness, and that's what we're here.
well, you were the spokesman for it, sir.
I represent the people, sir.
Okay, that's all right.
Switch to TurboTax.
Okay, you spoke about a probate issue, am I correct, that you were the executive, sir?
Yes, I did.
Okay, isn't it true, have you ever committed perjury, or have you ever committed forgery or anything of that nature? Oh, Your Honor, you just lied. Here's the paperwork, this impeachment with, isn't it true that you forged, my name?
What does this have to do with?
Well, it's impeachment, sir. It's impeachment, sir. People versus Sandway laws, the rules of evidence. Isn't it true that you forged my name, David McCurry, Paul McCurry, James McCurry, and Charles McCurry?
That is not true.
Okay, I have affidavits from him notarized where he stated that the brothers gave him permission to sign individuals' names, and the judge issued a show cause hearing. Give me a second, please. Okay, here we go. Here's an affidavit I would like to get a copy of to the prosecutor's office. It's signed and notarized by Norman McCreary. And this is allowed for impeachment purposes. He just committed perjury on the stand, Judge. And on page 2, Norman said that the other brothers, Charles, James, and Paul McCreary, agreed to getting the loan, the signing of their names. Oh, okay, yes. Could you, I'd like to give it so your witness can see it too. He just lied on those, sir. And it's signed and notarized by him in the Wayne County probate proceeding.
That was forged by the judge. It was not, and I had to follow the judge.
He committed perjury. And I have an affidavit from my brother on the phone too, that he didn't give me permission as well. And I'd like to have, that's what I was saying about witness call, Judge.
This is just an affidavit. It doesn't show anything about perjury. And not only that, but.
It's forgery, sir.
1 second, Mr. McCreary, one at a time.
In order, the court rule, in order to be impeached, it has to be conviction. Therefore, I'm going to object to this line of questioning unless the defendant can show that the witness was actually convicted.
Where is that case law? Show me the authority by that, that's why.
The court rule.
The Michigan rules of evidence
Judge,
allow for.
He just lied under oath, and he lied under oath in the courtroom.
For
That's
you,
why I like this
Mr.
subpoena.
McCreary, let me finish addressing the objection. Under the Michigan rules of evidence, to attack someone's credibility and to impeach them, you have to do it under whether or not the witness has been convicted of a crime involving dishonesty, false statement, or theft. If there's no proof of a conviction, I'm not sure how you plan on proving that with an affidavit that has not been verified by anyone, no court other than an affidavit signed by another person who's not here to testify.
This is affidavit. This is what I'm saying, it's signed and notarized. And then I was also previously, I had transcripts where I impeached police officers in Wayne County from complaints about them, and the judge allowed me. I just asked him, did he ever forge anybody's names, whatever else?
He said no.
And he said no. And the affidavit shows that he said my other brothers agreed. I have affidavits from Charles McCreary and other people that say they didn't give him permission. This is a felony. This is a crime, Judge. How can you allow this gentleman to come in here?
You have to file a police report for that crime.
I tried to.
Well, I can't.
They ignore. They've been vindictive to second prosecution. Your Honor.
I'm not allowing you to present an affidavit. There's no conviction of the 3 things: dishonesty, falsehood.
Okay, can you show me in the rules of evidence where that is? It says about conviction. Because other courts, I remember, I can't think of the chief judge from '99. He was here. He allowed.
1999.
Yes, Capers P. Harper was my attorney at the time. There was a deputy sheriff named Clifton Needed. And we asked for additional discovery to impeach him. And the judge allowed it at the time. I have this document at home as well. This is for purposes of impeachment. He just lied and said he never forged nobody's signature. And that doesn't equate to conviction or not. I have affidavits saying that, yes, he forged my signature, he committed felonies, and he did what he did. And this is his affidavit of truth.
Saying that he committed felonies?
It shows that he said.
Yes or no? Does it say he committed felonies?
Yeah, right here. It says that Charles and them agreed for him to sign their names. My brother has an affidavit saying that he did.
That's not saying I committed felonies.
Forgery is a felony.
I know it is. So is lying, so is shooting
and
people,
perjury.
so telling people you're going to kill them, so is murder. There are a lot of crimes.
So that's discrimination on your part.
If it hasn't been proven or established, then what do you expect me to do?
Well, I have the affidavit showing this contradicting what he's saying per my witness,
For the rules
Charles McCreary. And I would like to admit that in evidence as well. Because he's saying that he didn't forge these people's names, and my other brother's saying that he did.
For senior women who keep going strong, discover Lightweight All-Day Comfort.
And this for purpose.
Michigan rules of evidence.
And can you give me the rule?
609.
609, okay.
609.
Go here. You just lied under oath this time. MRE 609.
For purposes of attacking the credibility of a witness, evidence that the witness has been convicted of a crime shall not be admitted unless the evidence has been elicited from the witness or established by the public record finished during cross-examination, and the crime contained an element of dishonesty or false statement, or the crime contained an element of theft, and the crime was punishable by imprisonment in excess of 1 year or death under the law under which the witness was convicted. So the issue here is that there was no conviction. So
Okay.
I'm not admitting that evidence.
Can I
Move on to the next question.
give you, speak about the rule?
I'm denying objection. You place that you, disagree and object to my sustaining the objection.
Yes, I do object, and this goes also, again, I would like to renew my motion to recuse under People versus Crampton, Michigan Department of State, Crampton versus Michigan Department of State, Kane versus NBOC, because this court is being biased, and there's previous proceedings where the court allowed these types. Yeah, under in this court in
I didn't
99.
do that.
Well, what I'm saying is I asked him a question. He said, no, I have evidence to show he did.
I have the evidence under
And it
evidence
involved-
of 609 that allows for you to establish that. Next question, Mr. McCray.
Okay, now here, you just spoke on the rule, and I would like to argue the rule. It says unless solicited, I solicited from him and then dealt with that for dishonest crime. And this court, I feel, is being biased toward the prosecutor.
You're sounding like a broken record. I heard you already.
All right.
Denied.
Okay. Can I continue? And I object again.
Please.
Mr. McCurry, isn't it true that you consider yourself a sovereign citizen?
What does that have to do with this case?
Well, it's relevant. It's relevant.
Yeah.
Goes for credibility impeachments, Your Honor.
I object to the relevancy of the question.
It goes to the credibility of the witness and to test his credibility.
So sovereign.
People versus
sovereign-
sound. People
Mr.
versus
McCray,
sound.
the case law, you can stop right now. Rules of evidence. How is this relevant to the case here today, whether he's a sovereign citizen? And don't say anything about dishonesty, because you are too, and you've
How am
established
I
that.
being dishonest?
I said, don't say that it's about dishonesty, because you've stated that you're a sovereign as well.
I mean, yeah, I agree.
So what is
I'm
the
not
relevant
the
of
straw
telling you you're
man.
sovereign today
I'm
while
not
this has
the- I'm not the straw man. What I'm saying is,
Answer the question. How is it relevant that he's a sovereign citizen?
because he's the same person that fights you guys. In court, he's issued,
I'm indigenous to this land, where we sit and say.
Both of you all, I'm about to, in a minute, in this exam, there's gonna be some contempt here, going on. If you all don't stop. I don't care if he's a sovereign citizen or not. That has nothing to do with the case here today. So I don't find it to be relevant. So next question.
So you stated that I shot in the ear. Is that correct?
Yes,
Okay, you also stated that I shot at you as well.
yes.
Okay, is there any witnesses to this? And what time was this about?
Well, I can't remember this young man's name, but him and his mother was outside.
Okay, so what time was this?
I can't remember.
You can't recall. Does the people have this information, Judge, if he doesn't know the time that this occurred? Because on this day, I was at work.
It was
I was at work in Oak Park.
It was around probably after 5.
You just said you didn't know, Mr.
Well, I said I don't remember, but if I try to recollect, then I would say I get off work at 4:30, so it had to be after 5.
Okay, are you familiar, do you recall that I worked in Oak Park?
I don't know. I didn't know where you. You barely.
Okay, now let me ask you this, for your birthday, didn't I get you 2 bottles of rosé for your birthday? And I told you about it.
Objection.
Well, no, I'm trying to establish that he knows that where I worked at. This is what
I knew that you had got a job, but yes,
At
you
a
did.
supermarket.
Yes, you
Okay.
did.
To the McCreary's. If there's an objection on the floor, everyone has to stop talking.
Thank you.
For a couple reasons. The court reporter, you are torturing her right now because she cannot take down anything when everyone's talking. So please, one at a time. There's an objection on either side. Stop talking.
My body truly grew weary of bending over to trim my nails, often pricking myself in the process, until my neighbor recommended this electric nail trimmer and file. It shapes nails into a smooth, rounded finish whilst preventing you from cutting them too short. This is the all-new, upgraded second-generation electric nail clipper, featuring an enhanced nickel alloy blade and high-quality motor with a maximum speed of 16,000 revolutions per minute. Its combined clipping and filing function makes it more convenient. With infrared protection and automatic skin detection, it prevents hand injuries for enhanced safety. A single charge provides 6 months of standby time, making it more energy efficient. Includes an integrated debris collection compartment for one-touch cleaning, eliminating scattered filings for cleaner, hassle-free trimming. Built-in LED illumination ensures clear visibility in low-light conditions, suitable for independent use by children and the elderly. Crucially, the price is exceptionally affordable. I've never seen this brand priced so low before. It turns out to be a brand anniversary promotion, though I cannot guarantee how much discounted stock remains. Act quickly to purchase.
Hello, my name is Adam Ferrari, the Chief Executive Officer of Phoenix Energy. I look forward to you joining us at our next investor webinar, where you can drill deeper into our 9 to 13% annual interest rate bond offerings and see how our company has become an emerging leader in the oil and gas industry. In 2024, Phoenix Energy rose to become the 11th most prolific oil and gas operator in the Williston Basin, one of America's top producing regions. We are now right alongside industry giants like ConocoPhillips and EOG, and plan to continue rising in the rankings. Our daily production rates have risen as high as 18,000 barrels of oil per day. We've sold more than 4 million barrels, and we're just getting started. We hope to see you at our brief webinar. In less than 1 hour, you will learn more about our 9 to 13% annual interest rate bond offerings and the U.S. oil and gas sector. These Regulation D 506E bond offerings are open to accredited investors. Our team will guide you through the details of how to get started. Sign up for the webinar and start your journey with Phoenix Energy today.
So there's an objection. What is your objection?
Relevancy.
What is the relevance of the two bottles of
Well,
rosé?
to establish that he knew where I worked at, so that I can let it be known that I was at work during this time that he claims whatever this stuff is going on.
Okay, even if he doesn't know where you worked on that day and time.
Okay, this is what I'm
it's not
trying to.
relevant as to the day and time in which you were at work.
Well, the time of the crime that he stated. I mean, if how do you not know what time the crime was committed? You saying the date, but what time?
What time much you went to work, where you worked, or the time?
Well, what I'm
Because he
trying
said
to.
after 5. It had to be after 5 because he works until 4:30. He doesn't know the exact time. Is that my understanding of what he said? Is that correct?
Well, I worked afternoon.
Is that correct? What he just said?
Pardon?
He said after 5 because he just don't work at 4:30. Not sure what time, but somewhere after 4:30, after 5. Is that correct?
I mean, this is what he stated.
That's all I want you to say. We all agree on what was said. Okay, so he doesn't know the exact time. I understand. Next question is, how is the 2 bottles of rosé relevant to the day of the
Well,
event?
the reason that I stated that, Judge, is because he knew where I was. I was telling him about how cheap things were there with my employee discount. So he just stated he didn't know where I work, but he knows where I work. Because I gave him 2 articles from the job for his birthday.
Okay.
And then I have witnesses that I would like to call in, Robert Van Dyner,
Okay,
Gerald
you can call that
Flowers,
when
and
it's
other
time for you
people.
to roll it.
Yes, because Mr. McCreary was paid money. This is why he's.
Mr. McCreary.
Okay.
One
All right,
question
so
for
okay.
cross-examination.
Mr. McCreary, isn't it true that you allowed Mr. Robert Van Dyner and Gerald Flowers to rent the downstairs at some
I'm
point?
gonna object to relevancy.
Well, I'm trying to establish that Mr. McCreary is committing crimes, past and present. This is what this is about for purposes of impeachment.
No, for impeachment, you have, I read the rule, 609. Unless you have some other route, you asking questions about.
Well, the thing is, he's stealing money. If you look at the taxes, like the taxes is stealing my
And
mind.
guess what?
After
Even
10 years,
if
20
he
years.
was stealing money, it wouldn't be relevant today during this testimony.
So he can steal from me, and that's okay. And other people, it's okay.
No, it's not okay.
And I've made reports, and the 10th precinct is retaliated because I made reports against their officials down here for failure to protect.
You are
Judge.
muddying the water, not staying focused on what has been charged on this case.
Well, I'm being denied my rights. This is what I.
So I am going to sustain the objection, it's not relevant. Question?
Okay, isn't it true, Norman McCurry, that the taxes Mandy McCurry are still in her name after 20 years of being deceased, sir?
Yeah.
No, this your witnesses committed felonies and you're committing felonies with you and Kim work.
Okay.
And there is documented, I'm just, this purpose of
It's
it.
just, well,
The purpose of it.
okay.
May I ask you a question? How did you come to work here to court? How did you get here? Did you drive or were you brought?
Objection, Your Honor, relevancy.
Relevancy is Mr. McCurry is driving, he has no license. And
Okay,
he's
are you
breaking-
just trying to
he's breaking-
tattletale on him for everything
No, I'm
that he does all
impeaching,
day?
he's breaking laws, but I'm being accused, I'm innocent.
Okay,
I'm innocent,
it's still not
Judge.
relevant to the allegations and to what he testified to on direct examination.
Well, if I may respond, the relevancy is that Kim Worthy has executed things against police officers, but the witnesses are being allowed to commit perjury and get on the stand. This violates the officer's right, equal protection clause of the 14th Amendment. Because if officers have testified or lied and they were convicted,
What does the officer have to do with anything right now?
well, this is the witness.
He's not an officer.
He's a witness, though. It's just
It's not the same. This was a very specific case. We have specific testimony. I don't care if he has a license or not. So sustain.
But what I'm saying is,
I don't care if he has a license or not.
well, the police and him, they're being allowed to commit felonies, but I'm here to be accused. And this is, I'm trying to establish.
You're not being accused. You have it.
Okay, I'm being accused. I'm have been accused. Yes, and there's no evidence. Mr. McCurry, can I ask you a question? Did you know that there is no evidence in this case?
Objection.
Why?
How would he, he's not an officer.
Well, I'm just saying, there's no evidence.
And actually, there is evidence.
Where is this here?
Your Honor, his testimony is evidence.
That's not evidence under Upper versus United States.
Under the mission rules of evidence, testimony is evidence. Next question.
Okay, may I object under Upper versus United States, testimony without cooperative evidence is not evidence.
Yeah,
Jackson
so
versus Virginia,
That
and wait.
is incorrect. Next question.
I just say I'm being lynched today by this court as well as my brother.
Is this your closing argument? Because you can say that.
Well, I mean, you won't let me bring nothing in. You're shooting down everything that I brought in because of judicial bias.
It's not
Well, other
accurate
courts have
under the
called it
Michigan court rules of evidence, we have the Michigan court rules, under the rules of evidence, so I'm not lynching you. I'm denying you certain things that you're doing because it's not applicable and proper in court.
All right, now may I respond to the rules of evidence, statement that
No,
you made,
you can
Judge?
ask the next question that's relevant to the exam you're taking.
Well, I mean, I can't ask everything. You shoot down everything I'm bringing, Judge, and I
If you don't have
object.
any more questions on cross, then you can say no more questions. Have a seat. If you don't have anything
I'm
that's
being
relevant
denied.
to the direct test, the direct evidence that was provided, or the testimony on direct.
Well, may I address something that you stated, Judge, if I may?
Question to the witness.
I mean, I just yield because I'm being denied my rights, and I object to this whole proceeding because I'm denied to present evidence to call witnesses on my behalf.
No, you haven't been
To
denied.
properly
The people haven't
cross-examine,
requested for you to
to
even
properly
present
cross-examine the
any
witness. And then they're charging me with strangulation. It says injuries. No, this man is not hurt. He hasn't been shot. They got weapons and strangulation. I do all this to women. It's that wrong.
evidence.
This is what I'm
You
trying to
weren't- You weren't
understand.
charged with strangulation.
Yes, it's in here.
It says or by strangulation.
Okay. What's the first part?
Assault with intent to rape by violence.
Okay, assault with intent to grave bodily harm. He has not been hit. He hasn't been hurt. He hasn't been anything happened to him. Where's the medical report?
So it's that in the argument. You'll learn the elements. of
I mean,
that.
I just object and I'll rest and I'll leave it to the circuit court as
Well, you
well
can't
as.
rest. You haven't even had an opportunity
Well,
to
I'm just
present
saying
witness. Do you
because,
have any more questions of the witness?
I mean, I'm being denied my rights
Yes,
to properly
or no?
cross-examine.
Do you have any more questions of the
Oh,
witness?
no, because I'm denied the
Okay.
right to proper cross-examine.
Any redirect?
No redirect, no redirect, Your Honor. People have no further witnesses.
Mr. McCreary, do you have any witnesses?
I would like to call the chief officer that's the investigator on this case, and I also object to him not calling any other witnesses at this juncture because there's a witness list. And I would like all witnesses to be brought here so that I may properly examine and cross-examine these witnesses because they don't have a warrant, judge. Like after we had the hearing when he attested to court, I just had 15 pages. This is all that we have. Where's the warrant, judge? How am I charged? Where are magistrate's signature?
So as far as, this is the probable cause here, this is not, let me finish. This is not trial, okay? So the people do not have to present anything but what is necessary to show probable cause, not beyond a reasonable doubt. So if they want to call one witness, they can. You want to call the officer in charge on the case?
Well,
then him.
can I call all the policemen that are on the list? Since he's not calling them?
You need to offer of proof.
Pardon?
Offer of proof as to why you need to call them.
Well, because their investigation. This is what I want to question them as their investigation. How now the law is, I cannot be tried for a crime that I haven't been charged with. There has to be a complaint warrant and a request for a warrant, and there's not anything here. How was I even charged, judge? And there's no warrant.
So,
and out of the 15 pages I looked, and that's a violation of the Fourth Amendment to the U.S. Constitution, judge.
great. You said you wanted to call the officer in charge?
Yes, the officer in charge.
Okay.
And the other officers.
Now, I will allow for the officer in charge because he's here, correct, Mr. Milwaukee?
Correct.
Okay. For the rest of them, you did not subpoena or bring anyone today.
Well, I didn't know he was not going to put them on here. They're
It's
on
not
the
his
list.
job to call your witnesses.
No, what I'm saying is they're on his list as witnesses, and I would like to basically get the court to
He
have
did
a
not
clear
provide a
understanding.
witness list for exam.
It's a
In
list here.
discovery and investigation report, I believe, is that what you're referring to?
Yeah, right here, the prosecutor's office witness list. I have a right to this.
Okay,
And I
so
would like to cross
you have a right to interview them and subpoena them to come to court.
Well,
And
to
you
establish.
ask the people to make them available to interview also before.
Yeah, I understand.
And today we're here.
Well, in the
And-
6.10, it says I have a right to examine, cross-examine the witnesses of the prosecutor as well as myself.
You do.
And they had an investigation. I would like the court to have a clear understanding so these charges can or cannot be established properly under the due process.
I will allow you to call any witnesses that you have subpoenaed that are here today, as well as the people's witness who is officer in charge on this case who is also. Would you
Man.
call that? Mr.
Oh,
Martin?
yes, but man, I object to the court's denial of my Sixth Amendment right to call witnesses and also in the MCR 6.110, because to establish a proper investigation, this court to be full aware of what is going on with this case and the evidence concerning this case. I mean, these officers have to be brought forward so that we can ask them how they did the investigation.
And I believe that is a matter that you may, if you get bound over, can address at trial. There were several motions. It's the proper cause here, Mr. McCreary. It's very minimal.
Well, I mean, the rules are clear and under due process,
They
the
don't seem
statute
to
of
be
due
clear
process.
because you still talking.
Well, may I address the court? I mean, you give him the full rights to speak, but I'm always cut off.
Well, it's because you're saying things that really aren't relevant. So the officer in charge is here. Do you want to call that person that's there?
I definitely will.
Step up to the court reporter, give her your name and spelling. I swear you swear to tell the truth, no truth, and nothing but the truth.
Yes, Your Honor.
After you sit down, just make sure you speak up in the mic. Whenever you're ready, Mr. McCreary.
Can you give me like this, sir? Pardon? I hear you. Can you give me your name and badge number for the record, sir?
Officer Edward Pulowski, -4753.
You say Pulowski. Okay, so you're the officer in charge,
Yes.
detective? Okay. On the day in question, what time did Norman McCreary come into your station to make, if I'm here?
I don't know the exact time he came in right after the incident.
Right after the incident, so you didn't take the initiative to write down what time he came in here? He came into your office?
Your Honor, I'm gonna check the foundation. It hasn't been established that this witness actually took report from the witness.
Okay, so where's the
Let's clarify that.
Okay, I would like.
Lay a little bit of foundation as to
Well,
what his involvement
if
is.
he's the head
Mr.
officer.
McCurry,
Okay.
lay a little foundation, which means ask questions about his involvement to get to
I
the fact
understand.
that you're questioning whether he knew it or not.
I understand.
Right.
Okay, did you, are you the only one that had contact with Mr. McCurry?
No.
Okay, may you tell me whom Mr. McCurry started having contact with, in the beginning?
The officer Clannon who was working the desk.
Officer Clannon. Clannon?
Clannon.
Oh, Clinton, okay.
Clannon.
Clannon, okay. So you took the report, or Officer Clannon took?
Officer Clannon took the report.
Okay, and this is the report that's in this file that I made, this report here, sir?
You wanna,
I mean, I'm just asking, is this the report that the
I don't
officer
know,
took?
can you see that report?
That's not a report, so that is a written statement.
Oh, written statement?
Yes.
Well, it says an interview, like, it's questions are asked, and then the officer is writing questions, then he's writing the
I'm gonna
answers.
check, because it hasn't been established that this witness has taken that.
Well, he's the chief officer in charge of this case, so everything falls on him, just like you're supporting Kim work, sir.
No.
Everything you do falls on her.
What are you trying to establish?
Well, I'm trying to establish time, place, and things of that nature. I mean, there is allegations.
Let's stick to it. The very specific question you're trying to establish with this statement, what?
Well, I'm trying to establish a time frame. When did he come into the office? When did he speak?
Okay.
Who did he speak with? What time reports were made? You know, to clarify everything Mr. Norman Query stated.
Okay.
So I'm trying to lay a foundation as to this investigation.
Okay, and that's not the document that the witness has prepared or is familiar with, because if he didn't prepare that, then you can't present that to him and tell him to refresh his memory or recollection about it.
Well, I was just asking what time did Norman come in to make a report?
And your response was you weren't sure.
He said he don't know, so.
Yes, I mean, this is one of probably 300 cases I've had since then. I don't remember the time of every case that I have. It's all in the reports, which is public record.
Okay, so do you have the report?
Well, talking about for this report here, yes.
The witness just stated that he's not sure what time, but it's in the report. You have that report that he's referring to.
It says, I can't understand this reading. I mean, can you understand this? I mean, it says end time.
Don't read to me on.
Oh, it says start time is 5.
Mr. McCreary, when I read to me what's in the document, do you have it?
I have a police report, yes.
Okay.
I believe he still has a statement. If it's written pen, it's a statement. The report is all time.
Well, this was taken on the 10th, Your Honor, the day after the fact that I was.
You have your report or your investigator's report?
It's all in the jacket. There's an investigative report, there's the police reports, there's everything, the warrant.
I don't have a warrant. Where? It's not in here, Judge. He said he gave me 15 pages and he attested this is all he had of last proceeding. There's no warrant here. There's no authorization from the prosecutor. And then if he pulls anything else out, that's a Brady violation.
You may have it. What it's showing.
It's not here.
You don't even know what he's about to show you.
What I have in the packet, discovery packet, is the Troy Police request for a warrant, investigator's report. It starts on page 3 and appears to go through page 6.
National report you just had.
And this is even signed by the prosecutor, where they recommend or deny a warrant request. This is not even signed, it's not notarized, these documents are not
Okay,
legible.
let's stick to, do you want to
Yes.
present that report to refresh his recollection about time?
Well, no, I was asking him.
But that was the line of
No,
question.
that was not where I was trying to go. Where I was trying to go, I was asking him to get a basis. He stated that Mr. McCurry, my brother, came into the police department and made a report.
Yeah.
This report showed that he gave a statement on the 10th, so how it happened on the 9th? He said he went in there on the 9th, and this is written on the 10th.
That would be the day after. This is you testifying, first of all. There's been no testimony that anyone came on text.
Okay, well, look, I'm just saying he's objecting to everything, and I have foundation and right to ask these questions.
Ask about that.
Okay, so you stated that you're the chief officer in charge of this case, am I correct?
I'm the officer in charge, yes.
So you just stated under oath that you didn't know what time that Mr. McCurry came to the police precinct to make a complaint.
Not the exact time, no, sir.
Okay. Here, I would like to impeach him. Did you guys seek a warrant from Kim Worthy's office on this day in question or at any time?
I don't remember what date I sent it exactly, but yes, we sent the right back over to that prosecutor's office.
Okay, at your, what's the word? At your direction, did you order your officers to arrest me on the date in question, which when I was brought in for this case?
I didn't tell them exactly what day to arrest you. Once we do any kind of felony case, I gave them to our special operations unit who works out in 10th precinct. I know that there's probable cause to arrest somebody. If they come across somebody, they'll lock them up on the case, yes.
Okay, was there a warrant, sir?
Not at that time, no.
Oh, is there a warrant now?
There should be, because you're reporting.
No, sir. Right here, Judge, I would like to amend the evidence where right here, this is the Wayne County prosecutor recommendation. It's blank. It's blank. Now, my paperwork's supposed to be the same as his.
Your Honor, it is blank. The only thing that's different is that it's been redacted with the witness's address between his and ours. And that's perfectly legal, and that's to protect the witness unless there's a special.
You talking about the warrant, sir? Not the protection.
I'm explaining why the difference.
I'm not a threat to my.
So.
That's the last page of the investigator's report. That's not going to be an actual warrant. That's set in with every investigator's report.
Well,
the authorized warrant is going to be the black and white with all the charges.
Okay, can I ask you a warrant where?
So there is an information.
The objection, that's not signed, notarized, or approved by court, the court rule.
That would be a motion that you could address if it is found over regarding the warrant.
Right. Well, I would like to continue my cross-examination if I may, Judge.
Please.
How long have you been an officer? Officer Pulowski, you said it is?
Yes. In Detroit, over 7 years.
Over 7 years. Oh, you've been a police officer in another city?
Correct.
May I ask where?
City of Westland.
City of Westland. And you say you've been in Detroit how long now?
7 years.
Are you familiar with the restrictions of the Fourth Amendment to the U.S. Constitution, Article 1, Section 11 of the Michigan Constitution, sir?
I just put for a record that the officer isn't an attorney.
Well, but he's supposed to be a law enforcement officer. How you gonna be a law enforcement?
No, you don't.
Yeah, I know about the Fourth Amendment, yes.
Okay.
Okay, again, was there a warrant when you arrested me?
I did not arrest you.
Well, your officers, you should know what your officers are doing. Notice the agents, notice the principal.
Question, what's the question?
Okay, did your officers have a warrant when they arrested you?
No.
Judge, I move for dismissal at this juncture because there's nothing authorized by the prosecutor or anyone else. And he just stated he arrested me without a warrant. This is a crime. Now, I would like to state this. In 2001, the Department of Justice indicted DPD for dragnet arrests.
Okay.
And it's violation.
So I'm denying that request. You can be arrested without a warrant.
Can you show me the law where that is?
No, it's not my job to show you that.
Okay, well, I'm saying under federal case law and state case law under Article 111 of the Michigan Constitution of 1963, as well as U.S. Constitutional Amendment 4, enforced upon us, the states, they have to have a warrant, Judge.
32 hours.
72 hours.
Charged.
Well,
at some point, I don't know, but that's once again outside of the purview of this exam today.
They're committing felonies, Judge. This is the
Okay, and I am not the police department, I'm not the FBI, I'm not the Department of Justice.
Okay.
The charges here today are assault with intent to murder, assault with intent to do great bodily harm, less than murder, or by strangulation, weapons, firearms, possession by a felon, weapons, ammunition, possession by a felon, assault with a dangerous weapon, felonious assault, and also 4 counts of weapons and firearms.
Okay. Okay, do you have any video evidence of when Mr. McCreary came into the station, like body cams, which are mandated by law, so far as the desk officer, or you giving the interview? Are these articles available?
There is no body cam footage used on the front desk. It was all recorded at the station.
Okay, within the station, why haven't you put that evidence into discovery so that the people can have it? Sir.
If anything's requested from inside the station, it can be put in there, yes.
Okay. I'm looking for this page. Okay. May I take you to, I believe it's page 6, Detroit Police request for warrant before you was off, please, sir?
I don't take anything. I don't just take anything.
You don't have anything. Okay. Can I get the court officer to hand this to the gentleman so I may question him about this discovery investigation? Okay.
Last page? Last page?
No.
Of the,
I would like that back, but I would like to ask him a question when it concerns that.
so you want it back, or do you want him?
No, I want him to look at it and I want to question him about it.
Whoa, man, amazing car. When did you become a millionaire?
What is this for?
We're trying to get advice for the younger generation.
I made my first million last year, actually.
What line of work are you in?
I'm in sales.
Okay, what's the best advice you can give someone that's in sales?
You're only as good as your sales reps and your CRM.
What CRM do you use?
We used to use one of the old legacy.
But once he's done with, I'm going to be questioning him. I would like that paper back. That's all. Okay. Okay, you see the part right there where it says evidence officer. Can you tell me what that says?
None.
None. So how did you move forward if there was no evidence?
Mr. McCreary, you established what it is.
Oh, okay. That's the, can you read that for the record, sir, at the top of the page?
Well, actually, you would have to ask some questions.
Oh, okay. Can I see your Mr. Prosecutor temporarily because he has that?
Yeah, sure.
Okay, you have in your hand what's called a Detroit Police request for a warrant. Am I correct?
Right.
Okay, on the top part it says admissions and confessions. What does it say?
None.
Okay, lineups. What does it say?
Single photo lineup showing Mr. McCreary.
Okay, evidence.
None.
Okay, and then you have the witnesses. Then it says video. Can you tell me what that says, sir?
Body worn camera footage not available due to the report being taken at the desk.
Okay, and photo.
None.
Okay. So is this typically how the 10th precinct operates? No warrants, no evidence, they prosecute individual citizens? Is this how this happens, sir?
So when I submit one of these.
That's a question, sir. I'm asking the question.
Yes, this is typically what ours looks like when we send it in.
No, what I'm saying is this the procedure or the custom that your agency uses when they prosecute citizens so far as no evidence, no warrants. I'm saying, is this a policy or a custom with your department of 10th precinct, sir?
What policy just?
No, I'm saying that the operating of procedures so far as handling of investigations, prosecuting citizens when they're accused of crimes. Is this how you typically handle cases with no evidence, no warrants? You go get people. I mean, is this typically how your department runs?
Every case is different, sir.
Okay. Have you done this in your past history in Warren as well as Detroit, Michigan? Do you have a history of this, or?
Sending it down warrants? Yes, I have a history of sending.
Without evidence and without arresting people without warrants. This is what I'm saying. Do you have a history of arresting people without warrants or evidence, sir? This is the question.
I'm gonna object because he
If
did
so,
not, let him finish the objection. He's already, the witness has already testified that he did not arrest him.
Or have a warrant at the time.
well, what I was, Judge, what I'm trying to
You're
establish.
trying to establish way more than was needed for this exam. This is a whole, holistic type of approach you're trying to have here with the police department, Worthy, the bench. I understand that, but as far as this case, if you're not getting to specifics about what he did, he's not even seem to be that involved into what happened.
Well, what I'm saying is that right now you had a chief judge that just heard my motion to deny me because they're your supervisor. He's the supervisor of these officers. They move at his direction. If he don't move at his direction, that means they're vigilantes, Judge. They're just doing what they want
In
to
your
do.
opinion.
I mean,
So what is your next question?
well, my question is, does he have a history of arresting and charging innocent citizens without warrants and without evidence? And I know I
What's your
have.
answer?
No.
Next
Okay,
question.
I would like, now to establish that he's telling the truth, I would like to file a motion for the discovery under MCR 6.201, which allows this to his background history of complaints for false arrests or things of that nature. And I have transcripts before where this has already been approved in other court proceedings. And I would like to, at this juncture, subpoena his background history as to Warren as well as to Detroit, because if he has done this today to me, he has done this to many other individuals. And I would like the procedural and the substantive due process protection in this proceeding and the equal protection of the 14th Amendment. Judge.
I'm denying that request. I know you like to object. Please object to the record so we can move on.
Judge, I mean, now, like I already placed my objection, I mean, deny my rights to a fair trial.
It's not a
Okay.
trial. That's
Not my trial. Well, this is a hearing. What I feel entitled to my rights in a hearing.
Cause hearing. It's not guaranteed by the Constitution. It's a statutory right.
Well, if there's a federal right, we have two different opinions, all respect to the court.
And I'm sure mine is right when it comes to whether or not you have a constitutional right to an exam and whether it's statutory.
Okay. All right, I'm ready with my question. Okay, so are you familiar with the law in Michigan so far as state statutes, state laws, and things of that nature? Do you have some form of did you receive some form of legal training when it concerns your job? You went to the academy back in the day, whatever.
Yes.
Okay. Did you know under MCL 750.505 misconduct offers that is a 5-year felony that you have committed against me, sir, based on lack of evidence, no warrant, sir?
I'm gonna object.
Well, the objection is not founded, prosecutor.
Let him have his words, but I don't even know what his objection is.
Relevancy, defendants testifying, he's accusing of crimes.
Argumentative.
Argumentative.
I
So the question just doesn't make sense.
Can I respond, please? Sure. I mean, he goes for purposes of impeachment, Judge. And then, like I was stating, Kwame Kilpatrick was sent to prison for the same thing that he's doing. And I mean, he was the mayor.
You're not about to convince me anything,
Yes, ma'am.
mentioning Kwame Kilpatrick's conviction, so.
All right, well, I mean, can he answer my question? I mean, if he's a law enforcement officer, he should have no problem answering questions.
Well,
of the
it's
law.
not relevant.
Well, it's relevant because he's committed a felony, Judge.
That's an accusation that
It's-
has not been presented to this court in any matter other than you telling him that he committed.
Well, can I, again, ask this court on the MCR 6.201 Brady versus Maryland, request his background history for purposes of impeachment at People versus Stanaway, which allows.
More discovery?
Yes, I would like to, have more discovery so far as impeaching his witness
So,
because,
Mr. McPherson, if this is found over, I will sign the discovery order.
well, I'm just saying is I need it for purposes of the exam under MCR 6.110 to properly,
Discovery is
cross-examine.
an
his witness.
ongoing, it's ongoing.
Well-
So today, the exam, if we're in the middle of it, there's definitely a time to be prepared for this day. If it gets found over, I will sign a discovery order, and you can request.
Well,
Okay.
yes, ma'am. Under People versus State, again, I say that citation I would have today here in court with Judge Robeson dismissed a case against the prosecutor as a sanction for withholding evidence. He knew that his witnesses would be here, then he didn't.
That's an argument that you can discuss during the argument once you're on.
So he's not allowed to answer the question that I asked him so far. So,
No, I'm just saying.
okay. Are you familiar with Mr. McCurry or your department, the 10th precinct at all? Have you ever had any knowledge of him coming to your department or complaining about your department or anything to that nature?
For this case, I never had any contact.
Okay, are you familiar with the Sergeant Wall that worked at your organization?
Yes.
Okay.
1 second, sir. Is it the one that's retired or the sergeant?
He's retired.
Okay, because there's two balls there, two sergeants at some point. I just want to make sure I have the right one.
Yes.
Okay.
Okay, so when you did your investigation, how did you come about knowledge of McCurry beside with his brother? How did you know how Mr. McCurry looked? What information did you find out where he lived? Did you do a lien check? Did you check the system for pictures or addresses? Did you do any of that, sir?
So typically when I get a case, it pops up. We call it our hopper. It's where it lists all of our cases we got for the day. I make my initial calls, try to make contact with victims, get them in for another written statement because sometimes we get a police run. People's minds are elsewhere, or they don't ask the right questions. I might need more for my investigation. So I get them to come in, either me or someone else who might be you. Get a written statement from them so I get more of the story. That way, once I do send something like this over, whatever I get, I can put on paper and I turn it over to the prosecutor if they think there's probable cause to go forward. And then a magistrate thinks that it gets signed. If they don't, then I can only present what facts I have.
Okay. At your precinct, you guys have a warrant prosecutor?
A warrant prosecutor?
Yes. Typically, I remember from back in the day, they have assistant prosecutors available so that they can sign off and stuff like that. And that's relevant. He's bothering things.
This is why I stopped shopping on Amazon, and you should too. Don't spend another dime on Amazon until you watch this first.
Watch this. I can show you how to get the sweetest deals online when you shop from major retailers like Amazon and Target. You can drop prices automatically. I can show you how, but I can't do it for you. People are saving real money doing this. $160 million in the last year. Across thousands of different retailers, you'll
And also, I'm gonna jump from the whole shit. Other than you establishing in your argument that there was no warrant signed, what is your purpose?
I'm trying to show how his investigation came forth. I know I've read things concerning the Fourth Amendment. Fruits gathered after an illegal search and seizure are in court. And I'm trying to establish that. I remember back in the day that they had prosecutors readily available that could sign off on stuff like that. The prosecutor didn't even sign off on it.
Okay.
And I'm just trying to.
I'm sustaining the objection. It's not relevant right now. You can put that in a motion if it gets filed over.
Are you aware that Mr. McCurry, past and present, has come into your precinct, made complaints against your officer there?
Your brother, Norman?
No, me, Colonel Michael McCurry.
I'm gonna object. Always relevant.
It's for purposes of impeachment, Judge. That's how it's relevant.
Everything is for impeachment.
People versus Stanaway. Stanaway law.
It does not say you can impeach on anything. I know that case law does not say that. You can say anything in impeachment. That's not how impeachment works.
Well, I'm trying to show and establish retaliation by DP. Okay. Because of numerous complaints against them, because of recording them, putting them on YouTube, where they told an officer to break in the house.
Understand? Doesn't know your brother, apparently, until this case is filed, and doesn't know you. So can we move on to something else about what happened on the date and time investigation regarding you and your brother's complaint?
I mean, yeah, I objected again to this court's handling of this case. I had something in mind, but you proved me off. This gentleman here. Okay. Did you ever look at Mr. McCurry's picture? It was stated in here that you showed, or one of your officers showed Mr. McCurry, my brother Norman McCurry, picture. Is that correct?
Correct.
Do you know what picture it is? Do you have a copy of that picture here today in court? Because that wasn't in discovery.
It's included in my packet. It's in the APA's office. It's the Michigan SOS picture provided to me by the law enforcement information that we call lien.
And what came up in the lien? My driver's license, or what came up?
The Michigan SOS picture, yes.
Okay. All right. Your Honor, can I have the court officer show the prosecution's witness something?
Your Honor, yes, your witness.
No, I have.
What is it? I don't even know what you're trying to do.
I'm laying the foundation. He's keep trying to shoot
What are
me
you
down.
trying to do?
I mean, I'm trying to figure out how he came in contact with me, how he came about. He just stated in here, so I'm going to show him my driver's license. Okay. Did you ever look at Mr. McCurry? And I object, right, to the denial of that. Did you ever look at Mr. McCurry's driver's license?
His actual license? No.
Who, which Mr. McCurry?
Me, I'm talking about me when I addressed me. Well, Colonel McCurry. Did you ever look at Colonel McCurry's driver's license when you did the investigation?
Physical license, the one that's in your wallet? No.
Okay, but what I'm saying is in the system.
It wouldn't be your license, it would be the picture provided by Lean.
The picture by Lean. Oh, okay. Lean system. I didn't, okay, so I believe on the paperwork it says a CTN. What is that, a CTN, sir?
CTN?
A CTN, like on judgments, warrants, things of that nature. It says CTN, then it has ORI.
You asking me what a CTN is?
Yes.
So that's going to be generated by the system.
No, I'm saying, can you give me a breakdown and define what CTN?
It's not something I deal with on my end.
Okay, may the people, attorney, since he always wants to object, can you tell me what a CTN means, sir? And help you with it?
I'm not testifying.
Okay, so you don't know what a CTN, did you know that a CTN is?
I don't object to relevancy.
I haven't finished.
I don't see the relevancy of the CTN.
I'm just saying is I haven't finished my line of questioning.
Well, I can't imagine what a CTN has to do.
Well, it's a cargo tracking note.
I'm sorry, what?
It's a cargo tracking note.
Okay, and that's not relevant today. So next question, I know you objected to that as well. It's placed on the record.
So-
His objection to my CTN, he's saying that objection. Go ahead.
So you stated that you looked at my ID and whatever else in the link says.
Right.
Okay. Did you know, that me, Colonel Michael McCurry, reserved his rights not to be, governed or controlled by city, county, state, federal officials? Well, I mean, it's relevant. I tried to establish
It's
relevancy.
relevant to you, Mr. McCurry, but it's not relevant to the case here.
Well, it's relevant because I'm not the strong judge. I'm not doing business with the corporation. This is what I've been trying to establish, but you're limiting my
I am.
defense. My
I am.
defense, Judge.
I am.
What about the motion so far as additional discovery to impeach him for?
What did I say?
I'm not gonna help you.
What did I say?
And I have those
What
rights.
did I say?
You said after the fact, it was bound over, you will sign a discovery order, but I'm entitled to that to do a proper defense.
That's what I said. That's not going to change.
Well, under federal law, I have a right to present a defense, and this court is denying it. So
No, I did not deny you at all. We've been here for over an hour. You've been presenting things to us.
Okay, I can't question this guy because, this officer, because the court, the prosecutor keeps objecting, I'm being denied the right.
Well, maybe because you're not that great at cross-examining.
I'm very well, I have a right
You're not
to,
that well versed with the court rules or evidence.
well, I fight with constitutional law, which you have ignored, which you have.
Definitely fight with it.
Well, I'm just saying, under the
But-
Constitution, this court is bound by that.
I know what I'm about. Do you have any other questions?
I'm being denied, so I would just object, and then I would, if it's bound over, I would do a motion for a remand back to this court in front of the circuit court with paperwork. And, like I said, I'm in the process, I should be taking that down in this coming week to the federal court. And I would like also to have this case removed to the federal court.
Do you have
under
any more
removal.
questions of the witness?
I can't question
Yes
them.
or no?
No, I can't because I'm
Okay.
being denied.
Okay, any cross?
No, Your Honor.
Okay.
Thank you, Your Honor.
Any other witnesses or defense?
Yes, I would like to call the other witnesses listed on the paperwork.
And what did I say about that?
And you denied.
I said you did not subpoena them or ask the prosecutor to make it available for you to interview them for the exam today. So they're not here, so you're not prepared to call them.
Well, I just want to say this for the record, so just in case the higher court looks down the line at this.
Sure.
And like I tried to explain to the court, it was my intention based on the reading of the rule in the case law. It says even where you cannot show actual bias in the Supreme Court.
Taxes.
That you would be removed, and then I would have time to prepare these motions and documents. And I'm being railroaded by this court as well as the people who just admitted they have no warrants, they had no evidence. I mean,
The higher court, that's why I'm at the district court level, so that's what higher courts are for, so they can address.
But is okay, but may I respond to say something? Now, the law is clear. I mean, you took an oath under Article 6, Section 2.
I don't want to hear about it unless it's about your argument in response to people resting after they rest. Well, actually, they rested already. And you don't have any other witnesses present.
Well, I mean, I'm denying my witnesses.
You were never denied. You had a witness list, you didn't contact, you didn't ask the prosecutors to provide them.
I didn't think
or make them available for you to interview. Or contact them or subpoena them to come to them. This has been adjourned several times. You have plenty of time to do so. I've let you go to the library to research. I've let you even go to the court to file a lien against my house.
I'm waiting.
I've done way more than I should have allowed you to do. So I am not going to adjourn this or provide a discovery request to you or grant that based off of you not being prepared today to call witnesses that were provided to you on the witness list. So are there any other witnesses present today that you would like to call?
Well, I would like to respond if I may.
Yes.
Because you say I can't because I'm being denied.
Okay, so you don't have any other witnesses?
I mean, I have them. Yes, my brother Charles McCreary. I would like these police officers to be brought into court. Robert Vane, Diana Jurov. I have many other people that are willing to come into court and testify. And I'm being denied that. I would like to just again to clarify for the record that I didn't think that you would be moving forward because I was just in a court proceeding with Judge, what's her name? Where she denied the motion, then she sent it to the chief judge. Because from my understanding that if the judge grants it or denies it, then they have to send it to the chief judge. You never ruled granting or denying the motion per the court rule.
You accused me of being biased, so why would I make a decision?
I mean, but what I'm saying is you.
Why would I make a decision on something
what I'm saying so
where
far.
you're saying that I'm biased to you?
Well, I'm about to answer this. Like if you would have said denied, then you had to send it to the chief judge. If you would have granted it, okay, it would have been sent for a blind draw. Per the rules and under people versus
This is blind draw, this is not trial. This is the exam stage.
I understand.
Okay? So you don't have any further witnesses.
Well,
Today was an exam.
I mean, I have my one them at the exam.
They're just not here because you didn't subpoena them, ask them to come, or ask the prosecutor to make them available. So I'll be in.
Thank you, Your Honor. Your Honor, people move, bind over the defendant on all charges. It's a matter of it's a question of fact. We have one witness that says that the defendant took shots at him, put him in fear for his life. Defendant is a felon, convicted felon, and therefore he's not allowed to have firearms or ammunition. He attacked his own brother with bricks and a rifle. And there has been no official testimony of him not doing it, other than the defendant during his objections or arguments or whatever they are, saying that I didn't commit a crime. It's a question of fact. It should be found over. And the testimony was that it occurred in the city of Detroit, County of Wayne, so this court definitely has the jurisdiction under the court rules and the law to hear this and bind this over. And you know, he took aim at his own brother and shot at him. So we have to bind over on all charges.
First and foremost, I would like to object because by the officer's own admission and the prosecutor knows fully well, there's no evidence, Judge. Not just that, the witness lying here in court today, and he's not credible. He stated that he never forged any signatures or whatever else. And I have evidence to show the opposite, that he committed perjury right here on the stand. Also, I don't, the burden is on the prosecutor. I'm innocent until proven guilty per administration of justice. Again, I adamantly object and deny these allegations. He's stating that ammunition, all that. Where's the pictures of the guns, Judge? Like I stated before, where's the evidence at? Except my brother, who has lied in the past, and he has a dishonest history, and he has a history of theft. And let me finish. I didn't object you. I didn't interrupt him. I'm giving my code. I didn't interrupt him.
I'm just gonna object.
Just object.
That's fine. I didn't say that when he was talking.
We've been talking all day.
I'm gonna object because these are pulling facts that you try to get into evidence and they're not in evidence.
Mr. Salaki, I know the difference.
Okay.
Objection on the record. Mr. Secretary.
Okay. Under Opera versus United States, 348 U.S. 84, the Supreme Court held an accused extrajudicial admissions of essential facts or elements of the crime made subsequent to the crime are of the same character as confessions and corroboration by independent evidence is required. The requirement of cooperation applies to exculpatory statements to the same extent that it applies to incriminatory statements. The jury's finding in this case from the admissions of the essential facts together with all other evidence that the guilt of the petitioner had been established beyond a reasonable doubt is supported by substantial evidence.
Beyond a reasonable doubt is at the trial.
Okay, and I'm just reading this, like, to prove that the corroborative evidence need not be sufficiently independent of the statements to establish the corpus delicti. It is sufficient if the corroboration supports the essential facts admitted sufficiently to justify a jury inference of their truth, but those facts plus the other evidence must be sufficient to find guilt beyond a reasonable doubt. Now, I understand that this is just probable cause, but why waste the state's money and continue this ridiculous prosecution to proceed, Your Honor? They've admitted that they have no evidence. They've admitted that they have nothing but this man's word of mouth, who is in the community is known as a liar and a perjurer. And I wanted to call Chief Judge Burton, who's in Wayne County 3rd Circuit Court, to establish this, that he lied under oath, that he committed felonies. I mean, the prosecutor's office committed felonies, their witnesses committed felonies. I mean, it's factual. So at this juncture,
All of that is the trial. At the 3rd Circuit.
but again, I would like to object to this court's hearing of this incentive for judicial bias, because under Kane versus MPOC, it says that even if I can show bias, justice teaches that the judge should recuse themselves because you have been the target of criticism and so on and so forth.
Only by you.
Okay, but what I'm saying is, and I've been arguing the law, and the court overruled federal law, which states.
Some of it's bad law.
Okay, well, I've researched it. And I've shepherdized it, and it's still good law.
Okay. So, okay. Mr. McCurry, you have made your argument and objected for the record. Would you like to preserve that? Argument that there's no evidence presented today. What the court has to remind defense of is that testimony is evidence, whether you like it or not. I do believe that witness, Mr. Norman McCurry, was credible, and the burden of proof is on them, and they have to show at the probable cause standard. First, assault with intent to murder, that the defendant tried to physically injure a person, another person. There's testimony that the defendant, Mr. McCurry, tried to by not only aiming but also firing a gun at the complaining witness. Second, that when the defendant committed that assault, he had the ability to cause injury. In this case, he didn't have the ability. That was a deadly weapon that would definitely cause injury. And third, that the defendant intended to kill the person he assaulted and the circumstances did not legally excuse or produce the crime. That would be a question of fact, the trier of fact as to the intent of what Mr. McCray was doing. Pointing a gun, I do believe in the probable cause standard, pointing a gun and shooting someone shows intent to kill. As far as the remaining charges, assault with intent to break bodily harm less than murder is lesser included, satisfied by the evidence and testimony. The count 3, firearms possession by a felon has been established in Exhibit 1, in which Mr. McCray was not eligible to be in possession of a firearm, as well as count 4, ammunition in the weapon satisfies count 4, ammunition possession by a felon, and count 5, assault with dangerous weapon, felonious assault, has been satisfied based on the same testimony from the complaining witness and of course the 4 accompanying weapons, felony firearm charges. So, Mr. McCray, you're going to be bound over to 3rd Circuit Court, Framework Hall of Justice, for your arraignment on information date of June 29th at 9:00 a.m. I do not know if it'll be on Zoom or if it'll be in person. It depends on which judge you draw. Anything else from either party?
No, nothing from the people, Your Honor.
Mr. McCray, other than your objections?
I would like to place my objections on the record because throughout this entire proceeding, I feel that this court has been biased when it comes to rulings. They've even allowed this prosecutor to use state law to supersede federal law, as stated in Cohen's versus Virginia, that is considered treason against the United States Constitution. These are landmark cases. And also, you know, the witness lied under oath by stating he didn't do this, this, and that. And I mean, under substantive due process, the U.S. Supreme Court held that no matter what rules you create, you must use fundamental fairness. Well, I mean, you asked me everything else.
Anything else? Anything additional?
Well, I object. I mean, I'll just let you buy me over. And can I say one more thing? Again, like I challenged jurisdiction before testimony was even brought in.
And I deny it.
And, okay, but the law mandated.
Discovery order signed? Yeah. Okay, and what was it specifically that you?
I mean, I would like all the officers' background history, Kim Worthy's. I would like the individuals here today because it shows a pattern of history of felonies being committed against citizens.
So what I'll do is I'll sign this discovery order here, and if you want to expand it, the new judges you get across the 3rd Circuit, you can ask for those additional things like Kim Worthy's background. I'm not giving you that. Or ordering that. I don't even know what that is.
Well, what I'm saying is so far she's the chief officer of the county.
Yes.
And everything.
And I am not going to do that.
And everything that her subordinates do.
I'm signing a normal.
Well, what about the bond?
Scale certified discovery order for you to make sure that you have everything. In any video, it was mentioned that there was video possibly at the police station. This will get you that into the good. Okay?
Okay, well, what about the bond? I mean, I didn't run, I'm not a runner. Why do you got this tether on me? I mean, I can't get out of work like I need to. I can't get out and move. I mean, I don't know what my brother said. I'm not trying to do anything. This is a complete fabrication.
I give you a lot of leeway.
Pardon?
I give you a lot of leeway. I'm going to continue by.
I have a right to live. And my liberty is being restrained by these people who are committing felonies.
And the other option is within the Wayne County Jail with assault and attempted murder charges. 629 at 95. Okay?
And that will be all for today, ladies and gentlemen. Again, if you like this content and you're not subscribers to this channel, please do me a favor and subscribe to this channel and help this channel grow. When I restarted this channel, it was just me and Trin, the two of us. 8 months later, we now have 100 subscribers. But we can do better than that, guys. Come on, we can do much better than that. But that's it for today. What is on the schedule for tomorrow? Tomorrow's the 22nd. Oh, municipal court hearing. Municipal court. So that ought to be interesting. So you all have a wonderful evening. Let me cue this up. Or I forget. So you all have a wonderful evening. Ta-ta and ciao. I will see you guys on the next one. Have a good one, everybody.